I'm Bill Auten of Auten Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims
Good
adjuster.
morning, Bill.
Good morning, Chantal. How are you today?
Oh, I'm because
Yeah,
I'm like because I didn't sleep last night. So
a little under the weather.
yeah, little cranky and all of that kind of stuff. So I might be more cranky than usual, which
Who
which will
knows?
which will be ironic, or I don't know, something new, I suppose.
I
Um,
got broad shoulders. I can handle
Uh,
it.
yeah, and so you know what people should do is share and comment and like and subscribe to the podcast so they can hear me be more cranky because I didn't get enough sleep in the
Yeah.
evening or whatever. Yeah, been up since like
Well,
3:30.
you are
Woohoo!
you are radiant as usual. So
That
whatever's
check
going
is in
on,
the
you're
mail.
hiding it well. So
Yes,
today is
yeah.
inaugural flight with my stand-up desk. So
I could tell something was different. You were looking. I was like,
do I
you
look
taller
taller?
today? Yeah, you're taller today. What's going on with that?
Everything behind me looks shorter, I think is what the
It's
deal
all
is.
about perspective. It's all about perspective. We
Right.
are talking about something that comes up a lot in insurance claims, especially liability claims in this time of year, which is slip and falls, trip and falls. You know?
Yes, well, we actually categorize them differently here.
Hmm.
Trip and fall is a little different than a slip and fall because the mechanics are just a lot different. And there's, different reasons for a trip versus a slip,
Hmm.
and notice issues are different on those types of claims as well. So
That would that would fascinate me. Go ahead.
yeah, well, we treat them, we have separate categories for them,
Hmm.
and
So we're going to
slip.
stick solely with slip and falls today because usually I put them all together because yes, I mean, they are kind of separate. With a trip and fall, obviously, you're going to be tripping over something like a rug kind of bunched up or whatever versus a slip and fall, which is a slippery situation like ice or water or something to that effect. But I always have categorized them together, but I didn't realize that the notice is different. So today we're going to focus specifically on slip and falls. Is that right?
That's right. And I don't think when it comes to notice, I don't think there's any legal issues that
Mm,
we
mm.
that bear on a slip versus a trip. It's just the discovery process that we go through.
Oh, I
What we're
see.
looking for is much different.
Mhm.
So, trip and falls are going to be a lip on the sidewalk, maybe, or a bunched up rug.
Mhm.
Anybody who falls down a set of stairs, we put that in the category of trip and falls. Um,
Okay.
Now, if the stairs are icy, we could
Okay.
call that a slip and fall.
So would
So,
we what would that be? Would that be a a strip and fall?
ooh, that sounds.
That which would be a whole nother category.
Yeah, we don't have
Um,
that category, but that would be an interesting claim to
That would
handle.
be an interesting claim. So when people hear slip and falls, what do you think usually people get wrong right out of the gate?
Usually, what they get wrong right out of the gate. Wow, that's interesting. Um, I can't tell you what they usually get wrong right out of the gate because there's so many things that can muck up the investigation or change the course of the investigation, I should
Hmm.
say.
I would think that one of the first things would be, and you comment and you wrote about this on LinkedIn the other day, is not doing that scene investigation right away. Uh,
Sure.
because especially if we're talking about a slip and fall where there's an icy situation, we're talking about weather.
Right.
So, coming in the south, it can sleet and ice up, but by, the next day, it's melted. And so getting those photographs of the icy environment or asking your insured to at least get some, which may not be the best, but you know.
Yeah, well, oftentimes, like we just received an assignment today that the incident happened on October 30th.
Hmm.
So we can run out to the scene today, but it's probably going to be different in terms of weather.
Right.
Whether there was ice that day or not, I don't know. I
Yeah.
do know between then and now, there's been a lot of different types of weather.
Mm.
As I said earlier, today's 48 degrees. 2 weeks ago, it was like 20 degrees.
Hmm.
So yeah, but getting out there right away is definitely something we have to do right off the bat. And if we know it happened today, ideally we'll get out there today and take a look at it.
Right.
Not
And
always
and
possible.
and for the adjusters who can't get out there, like if you're a desk adjuster or whatever, assigning someone like Bill, who's your eyes and ears, like you're independent, and asking them, hey, could you swing by on your way home or something? I mean, we need to get pictures today.
Yeah.
It's very, very important not to let those things sit.
When it comes to preserving a scene, the best way to do it in slip and fall cases, whether it's inside slip and falls in restaurants or, you know, grocery stores or whatever, or outside, is security camera footage,
Mm,
because that'll capture it in real time and you'll be able to actually see what the conditions were as it happened. Um, so if you are a property owner, especially a commercial property owner, and you don't have cameras, you don't have to spend a ton of money to get a system in place. There's a lot of cheap options out there
mhm.
that do a pretty good job. So I would
Yeah.
encourage people to do that.
So again, the other thing for the adjusters to do would be to ask your insured, hey, don't save that video, and
Yeah,
and rem- and
don't
and
delete
be
it.
yeah, and be aware that sometimes it's like on a 24-hour, they delete on 24 hours or 48 hours or 72 hours. I mean, it's oftentimes very short. So
Yeah.
again, I know you're busy, but when you get these new claims that say slip and fall or whatever, it's of paramount importance that we secure that scene right then and there.
I would say if your system deletes things within hours instead of days or weeks, that you need to invest in a new system.
Mhm.
Um, and maybe your system is really outdated because a lot of the very inexpensive systems
Mhm.
today will
Mhm.
save videos for 30 days. I have one at my home. It's cheap, and I should find out if they have affiliate links, and I'll put them on my website because they're
Yeah.
really inexpensive. They save videos for 30 days. And anyway, preserving evidence is one of the things that a common thread throughout any kind of claim we have. So when we know or suspect that there is video, we will send a preservation letter to the insured asking them, directing
Yes.
them to make sure they save that. And oftentimes the first letter from the attorney will do that as well.
Yeah.
They'll issue a letter that some of them are very, very long. We've got some notice letters from attorneys that are 3 or 4 pages outlining all of the evidence that they want them to preserve, and they're a little
Oh,
heavily worded and
spoliation.
yeah, yeah. But
Woo.
uh, but if you can save those videos, that's most important.
Yeah, and that's all about like notice and loss prevention, basically.
Hmm.
Uh, because again, it's us all getting on the same page. And you're right, video is like the best way to see that because then it's not anyone's interpretation of what
Yeah.
happened. So,
Yeah, and if you're a property owner and you have and you don't have cameras out there, chances are you have a cell phone. Get out there and take some photos to preserve it yourself.
mhm,
That's something that not only will help your insurance company to defend the case if they need to, but uh, and even if it's bad news, that's fine.
it's fine.
If it looks terrible, capture it, so that we know what we're facing, so that the
Yes.
decisions can be made properly early on.
I think that's a very good thing to point out, Bill, is that even if it's bad news, speaking from or to the either homeowner or business owner or whatever, and then also speaking to the adjusters, our job is to pay covered claims. I mean, that is literally the reason why insurance exists, right? Is to pay covered claims. And so if it's bad, quote unquote, meaning you did have water on the floor or you had a grape on the floor and you didn't notice it or whatever and someone slipped on it, that's okay because that's what you got insurance for, so to
Right.
speak. And so then you just take these pictures of the situation, you send them off to your adjuster, and as an adjuster, you look at these, you apply the ABCD rules of liability, you look at coverages, and if everything ticks off as a yes, you get a green light, then you pay the claim and we
And
move
don't
on.
just gloss over the ABCD, because there may be some new listeners who haven't
Oh,
heard you talk about that yet. So, what
okay.
is
So
ABCD?
are we going to do our alphabet? A, B, C, D. No.
You can.
Okay. So I call it the ABCD rules of liability or negligence. And there are four features of negligence that you have to have all yeses to in order for liability to be triggered for the insured. So, does the insured have a duty, right? A duty to keep the property safe, to not have water on the floor, to not have icy steps, to not have food on the floor or ice on the floor where people would slip and fall in a restaurant or something like that, right? Do they have
Yep.
a duty? Okay, that's the A. Was that duty breached? That's the B, breached. That means did the insured have water on the floor, ice on the steps, uh, grapes in the grocery store aisle, whatever, banana peels, banana peels. We haven't talked about banana peels. Then and if they do, if they've breached that duty, we've got two yeses so far. The C is did the breach of that duty cause the accident? Because again, we have to be able to link that duty, the breach of duty, and to the accident. Did that cause that accident? The proximate cause. And if the answer is yes, then we move on to the next one, which is did this breach of the duty create damages? D for damages. And if you've got damages, then woohoo, you've got all four yeses right there, A, B, C, D. And then we also link this over to coverage. Do we have coverage? Because again, and I tell my students this, it probably took me 5 years. I knew it intuitively, but I just want to normalize this for people. I knew it intuitively, but I probably didn't recognize it and be able to say it out loud to until much later in my career. Liability is a two-step process. You not only go through your ABCD rules, but you also look at coverage. So it is perfectly plausible in the world of claims to have your insured be liable for an accident, to be negligent for an accident, to be responsible for an accident, but there not be any coverage. And if
Sure.
that's the case, we don't pay. The
Right.
insurance company does not pay because you don't have two yeses. It is perfectly plausible that you would have coverage and you didn't breach a duty or something like that. You still have a yes no, and in that case, we wouldn't pay.
Right.
And the issue is that many claimants, because they're insurance consumers, don't understand that. They think
That's true.
I slipped and fell at this store or at the convenience gas station, or outside on the steps or whatever. therefore you're responsible.
Right. It
Maybe,
happened
maybe not.
here. Yeah.
Yeah.
And as far as there being no coverage for most slip and fall claims, there's probably going to be coverage, but not
Hmm.
always. If it's an employee, there's not going to be any coverage under the general liability portion of the policy. If you didn't pay your premium and it was canceled, there's going to be no coverage for it. So
Hmm.
there's lots of reasons why there could be no coverage in a given scenario. But um, yeah, so liability. You've used the word notice several times here, so let's
Yes.
talk
Sorry.
about
Yeah.
notice
Yeah.
and how that triggers liability and negligence
Hmm.
in a scenario where someone, slips and falls. Um, of the various types of slip and falls, we've got outside with ice and snow. We've got inside with banana peels, grapes, spilled liquids, ice
Hmm.
cream, whatever. Um, and the question is, was that hazardous condition known to the policyholder or the property owner prior to the incident happening?
And I think this goes to the duty breached part of
Right,
it.
right. Because
Be
if they had notice and they didn't do anything, then they breached their duty.
right.
But
Yes.
the big question for an adjuster is finding out whether or not they knew of the
Hmm.
condition.
Hmm.
And so in weather conditions, you can argue, well, everybody has access to what the weather's doing. You just
Right.
have to look out a window.
Right.
In a store or a grocery store or a diner, things are different. And I
Yes.
can give an example.
Please
We
do, because
have
I've got an example for weather.
great. I've got a restaurant example. This was a kind of a buffet restaurant. So people could go up and just fill their plates with whatever. And this place was really good. They had cameras everywhere, thankfully. And
Mhm.
they also had staff. The protocol for the staff was to walk up and down the aisles and make a round, and it would take them 20 minutes to go through the entire building. So every 20 minutes, there were two or three employees that would have to come back up to the station and initial a card showing that they actually made their rounds.
That's
So it was
brilliant.
really good documentation.
Yes. Be sure y'all get this as adjusters when you have,
Yeah.
yeah, ask for these things.
Ideally, you'll have a restaurant that does this, but not
Yes.
all restaurants do this.
No, but you should still ask.
Yes. Yep.
And then put that in your notes too, that you've asked for it and Insure doesn't have it.
Yeah. And if you're a restaurant owner,
Get
do
it.
something.
Yes, do
Just
something. Go ahead.
it's a pad of paper.
Yes, absolutely.
Um, so the cameras showed that this person walked down the aisle with a broom and a sweeper, and they were doing their thing. And less than a minute later, this young lad with an ice cream cone came running down the aisle, and a big glob of ice cream fell off of his ice cream cone. And then an older woman came by, didn't see it, stepped on it, slipped, fell, and hurt her shoulder.
Mhm.
So the question we had to ask is, did the restaurant have notice, or should they have known? Did they make an effort to know?
Right. And I would say they had no notice
They had no notice.
because our employee had just gone down the aisle. There was an intervening incident, which is the kid, running the ice cream dropping, and then the woman, having a slip and fall in that instance. But you tell me what you think.
Yeah, that's pretty much the outcome that we had. I think at the end of the day, we wound up settling just for out-of-pocket um, medical expenses, which is automatic under med pay provision anyway. It doesn't
Right.
require liability. So that was a happy ending there. And um, but the net of that story is that the net result rather is that we have to have notice. And if you're making efforts to clean up during changing conditions, um, you kind of get a not a pass, but you get some latitude when it comes to liability
Hmm.
if you can demonstrate that you're making efforts. And uh, we have the storm in progress defense for claims
I didn't talk
outside.
about. That's what I was
And
going to talk about.
And
That's what
that's
I was
what
going
you
to talk.
can go ahead and explain what that is.
Yeah, so I have some uh, oh colleagues, I guess, or people I know or whatever, and they live in apartments and they swear up and down that their landlords are slumlords.
Hmm.
And it's mostly because right after Kansas blizzard has come down, and there's not someone sweeping off or shoveling the stairs and the walks and all of that to the parking lots and de-icing all of that. And I talk about the fact that we've got a storm in progress, so nobody is supposed to be out at 2 a.m. shoveling the sidewalk. You know, you're not going to get in, you're not going to get dinged for that.
Right.
You're not going to be liable for that. I don't even think, and again, not an attorney, not offering legal advice, but I don't even think the law requires that. And then even after the storm is passed, you get some time. I mean, it's not like you gotta wait until the last snowflake drops and then you gotta start shoveling really quickly.
Right.
You know what I'm
Right.
saying? I mean, you get, I don't know, 12 hours or 24 hours or, something like that. You get a minute, basically. And these, bless their hearts, as we say in the South, these people just do not understand that. And they do refuse to go outside because they're deathly afraid that they're going to slip and fall and break something. And I'm like, this is fine. I'm sure your
That's an
slumlord.
excellent risk management strategy is to
Yes,
not go out when it's icy.
yes, I'm sure your slumlord appreciates this, but
Hmm.
also, um, yeah, they wouldn't be, even if you did, it's not their fault,
Right.
because again, here's something we haven't talked about is that it is also the person who is walking, meaning the claimant, it's their duty to keep a lookout. We talked about, the duties to keep a lookout when we were talking about auto claims a couple of
Hmm.
episodes back. Same
Hmm.
thing. Like the woman who slipped and fell on ice cream, she's supposed to be looking where she's going.
Right.
So it's not all of the insured's fault.
On slip and fall claims, and I just had a conversation with a claimant about this who had fairly serious injury. And, I explained that in weather scenarios, especially last year where we had layers and layers of ice build up over a couple, probably 2 months,
Mm-hmm.
and there were shortages of salt and ice mitigation materials in the area. You just couldn't get anything. So property owners were really in a tough spot.
Mm-hmm.
Um, that being said, property owners still invite people to their place, even the restaurant, the buffet that I had discussed earlier. They're inviting people to this environment where you've got random people walking, children walking around with plates full of food. Chances are that, that's an environment where that kind of thing is prone to happen. That's why they have the protocol in place. But how much is enough? Like, should they have somebody going down those aisles every 5 minutes or every two
Oh,
minutes or
right. And
uh,
that's a good point too.
yeah,
We've probably beaten this to death, but it's just what a quote reasonable end quote person would do, and that's going to be a jury member.
right. And that's a pretty squishy kind of definition, but that
Hmm.
is the definition of, that's how you determine those ABCDs
Hmm.
is what would a reasonable person think about that duty and the breach of the duty. Um, anyway, the as far as apportioning liability in a slip
Yes.
and fall case, yeah, I think that in this climate where we are, when you have winter conditions, I don't think anybody can be tagged as 100% liable for the incident.
Hmm.
Um, I think if there is any shared liability, it's apportioned between both parties. I find it difficult to assign less than 50% to the person actually walking.
Mm,
I think that they have a duty to watch where they're going, to wear the right footwear, to, be cognizant of the the scenario they're putting themselves into. That being said, the property owner should keep the place safe.
right.
So,
That's part of their duty.
yeah.
And so, how do you have that conversation? Because I think a lot of times adjusters have difficulties with conversations with claimants. Because, of course, it's so much easier just to accept 100% liability and pay 100% of the bills. But to tell a claimant, look, I think that you're at least, you know, 35% at fault because you weren't wearing, you were wearing high heels walking on ice, even though it was going to be a gala event. You could have worn tennis shoes and then changed,
Right.
as soon as you had gotten inside or something. Um, uh, Most people don't like to hear that they're at fault. So how do you talk to people like that about that?
Well, the first thing is to be sympathetic to their situation and tell them that you understand the grief that they're going through and that this injury that they've had, that you've had experience with it from a claim standpoint, and that you understand that it takes several months, maybe even a year to heal completely, and
Mhm.
that it's upset their lives, and acknowledge that, and you should internalize that as an adjuster, because if you don't and you come off as just you know casting blame on them for their own injury, it's probably not going to be received very well.
Uh-uh.
um,
No.
so so acknowledge what they're going through, and then explain to them that there are some mechanics involved in determining liability, and the ABCD thing is a great way to do it. The way I just described, the weather conditions and how people have an obligation to navigate through icy conditions
Uh-huh.
safely on their own as well. Um, but then also acknowledge whether or not there's something wrong with the premises that should have been corrected.
Uh-huh.
Um, and say, look, in an ideal world, there'd be dry pavement for you with no ice, but that wasn't the case that day. And you know, who's at fault for that? Well, Mother Nature played a pretty big role. So, but she doesn't have an insurance policy, so
Yeah,
we have to, yeah,
unfortunately.
yeah.
Otherwise, she'd probably be bankrupt or at least like self-insured, maybe like a huge, a deductible or whatever. But something um you're talking about uh, mentioning these things, and we should talk about the fact that this is one of the very first kind of conversations that you would have with the claimant. Maybe not your first conversation because you're still gathering information, but definitely when you decide what liability is, that's when you need to be having that conversation. The earlier you have it, the better it's going to be for you. And yes,
Yep.
they can get a contract or not contractor, excuse me, an attorney or whatever. Because I was thinking of the snow. I was thinking of like snow plows and are they in subrogation? Are they being brought in and all of that stuff? But that's just another topic. Just real quick, I just wanted to finish talking about how we discuss splitting this liability, telling the claimant, yeah, you're kind of partially at fault too.
Yeah, well, I mean, you can word it that way, but
I'm not, yeah, don't say that because that's way too blunt. I'm way too blunt. Don't listen to me. Why are y'all listening to me? In fact, like, subscribe, and follow, and then tell everybody don't listen to me. That's what we need to say. Maybe we'll get
well,
more listeners. Uh,
one question that I like to ask in just about every case is, what was the cause of this? What actually caused this?
mhm,
And if it was ice, they'll say the ice, and if it was a grape, they'll say it was a grape. Or they may say it was the abject failure of the property owner to maintain a safe premises. I've never heard anybody say it like that, but
Well, I'm going to tell
I've
you.
heard it in so many. Well, I actually have heard that from something like that from an attorney.
Yeah,
So,
well, okay, yeah, because what I was going to say is if you hear something like that, all of your hackles should be raising because that means that there is an attorney back there somewhere.
yeah, right.
Who
But
she hasn't declared herself yet by sending a letter of representation, but there is an attorney back there, and you should pay attention to this.
yep. So I think we've kind of nailed down
Yeah.
notice.
Yes.
Let's talk a little bit about contribution. Now, you said the word subrogation, which was interesting. Um, and we refer to it as contribution. So in a snow plow situation,
Yeah.
we'll look at the snow plow operator or contractor to see what their contract says and what their obligations are under that contract. Now, in New York, for a snow removal contractor to become liable for a slip and fall, they have some very strict rules under a doctrine called Espinal.
I
It's
thought
a
you were going to
legal
say
case.
espionage, and I'm like, ooh, let's
No,
talk about that.
it's not espionage, but it is Espinal, and it's Espinal
Boring.
versus, it's over there.
It's boring.
We refer to it. What's that?
I said it's boring.
Espinal?
Yeah. If it's not espionage, it's boring.
Oh, I get it is pretty
Jeez.
boring, but it outlines the duties that contractors have, and they may become liable if the property owner kind of relies on them. Like if you got a contract where the contractor says, "Don't worry, we'll take care of everything. We're going to make sure there's no ice and no snow. You don't have to worry about a thing." If that's kind of what their contract says, and that's kind of what they promise to do, and a verbal contract counts.
Ooh.
If that's the case, then um, anybody slips and falls, it's pretty much gonna the contractor is gonna have some shared liability here.
Mm.
May not be 100%, but they're definitely gonna come to the party.
Hmm.
If their contract says we only come when the snow is 3 inches or more, and we only apply salt if you ask us to, that guy is not going to be involved
Okay.
because as long as he did what he said he was going to do, if he was there when it was 3 inches and he plowed like he said he was going to, and the property owner never asked for salting services, then there's probably going to be no contribution from the contractor, and that's a very very simplified kind of
Sure.
look into what Espinal says. There's a lot of other things, but
Well, I have a question again for our adjusters. I'm acting as our new adjusters or whatever. So let's say that we do have two people who are going to be at fault, right? Our snowplow didn't come. It's been a foot of snow, and our snowplow didn't come, and insured didn't ask for salt. So insured is responsible for putting salt on the sidewalks while our snowplow is supposed to be doing the parking lot or whatever, and someone slips and falls. And I don't know, I guess it would depend on if it was the parking lot or the sidewalk
Well,
where they slipped and fell.
that makes a difference too. If the contract
Or
says they're going to plow the parking lot and nothing about sidewalks, then that contractor is really not going to be responsible for somebody who slips and falls on the sidewalk.
because I was trying to figure out how we again have that difficult conversation with the claimant of, yeah, I'm only going to pay, I don't know, 25%. And this contractor who's not involved in this conversation because I don't have his policy, I'm saying he's 75% at fault because their insurance company is going to be like, yeah, we're only like 50% at fault. And anyway,
Hmm.
point being, you got this gap. And whatever, but
That's where conversations come into play, where
okay.
if you're the adjuster for the property owner, you want to get on the phone with the adjuster for the snow removal contractor and
Hmm.
have these conversations and kind of work together to come to an agreement if necessary.
Yes.
It may be that you all have a different opinion about who's responsible for what.
Mm.
And if that's the case, then it it becomes a dispute that may end in a statute of limitations, just ending the claim or an eventual lawsuit. So,
Yeah, or I guess you could go to arbitration. But the point, though, being is maybe I don't know if it's joint and several liability, which we have never talked about, and would probably be a good thing to talk about. But where we would pay for all of it and then subrogate for a certain amount or whatever.
yeah, we
Yeah.
never see that kind of thing where, and I don't even know if you can here on a third party claim, if you agree to liability
Mm,
and settle it with a claimant in exchange for a release,
mm,
and then you go after an at-fault party, I think you're going to have a bad day and spend a lot of
yeah.
legal expenses to do
Okay.
that.
All
So
right.
we usually try and get them involved up front and get
This
their
is so important.
position.
Mhm.
Yeah, yeah.
Mhm. This is so important. And again, I don't think a lot of our newer adjusters know this. In fact, there was an article in the CPCU Insights this past quarter talking about about how adjusters don't work together,
Hmm.
especially if it's like two things like a flood adjuster and a property damage adjuster. We no longer talk to one another, and that is so important. Find out from the insured who their flood carrier is or who the contractor insurance company is for that, and contact and work together.
Yep. Put them on notice right away
Hmm.
and get them involved. If they ignore you, certified letters help.
Yep. Yep.
Sometimes I need to go to their office and knock on the door to get some attention.
I have found, yeah, no, I totally agree. I have also found there was a letter that I used to send. It was a standardized letter that we had in our group, which would be sent to that at fault carriers or partially at fault carriers insured.
Mhm.
And it says, hey, we've been reaching out to, your adjuster at, Insurance R Us and blah, blah, blah. And, they're not calling us back or anything. Gonna let you know that we still find you responsible. And if so, we're going to bring you into the into a lawsuit. You need to tell your adjuster to call us. And then I would CC that adjuster and send it all,
Hmm.
like you said, certified, blah, blah, blah. And amazingly, I would get a phone call.
Yeah.
I don't know why, but I would get a phone call.
Well, at the end of the day, the responsible parties are actually the parties involved. The insurance
Yes.
companies are the kind
Yes.
of the afterthought that indemnify,
Hmm.
and lawsuits again are against the property owner or the tortfeasor. They're not
Yeah.
against the insurance company. They
Mm-mm.
can be. You can sue an insurance
Yeah.
company, but in most third-party claims, your claim is against the person that you believe caused your injury.
Exactly, exactly. So we have done the first steps, and we've accepted liability. Now the issue is we need to gather medical records, and there are Medicare, Medicaid, ERISA plans, this sort of thing. And then, of course, we have that whole thing where, what is it, CMS? We have to declare the claimant to CMS to find out if they are a Medicare or Medicaid recipient and if Medicare, Medicaid has been paying. So, can you kind of walk us through that and what the issues are if we don't do this?
Yeah. So let's see.
It's like, oh, there's so much. Yeah.
So everybody, most people have some sort of health insurance available to them in whether, even if it's just Medicaid. It could be that, it could be Medicare if you're over 65 or if you have other problems that you're eligible for
Mhm.
Medicare. And the private insurance could also be there. And then that would be either a private insurance company or, like you said, an ERISA plan where your employer is actually self-insured for health insurance benefits for their employees. And in New York, if you're just a private insurance company, you can't subrogate for damages. That changed about 2009, I think. So if you've got like Excellus Blue Cross Blue Shield here in New York, any benefits that they pay to you for your medical bills, they can't go after the at-fault party to recover any of those benefits.
That's interesting.
The only way you can do that is if it's an ERISA plan.
Mm,
And also in New York, well, I think this applies to every state, but if Medicaid can put a lien on your settlement,
yes.
so anything that they pay, they're going to want to be paid first, and then
Yes.
CMS or Medicare,
Yes.
they're going to be there with their handout as well. So
Yes.
carriers need to have a mechanism in place to report your claim to Medicare. Carriers have that in place and they do that. We don't do that here.
Mm.
Um,
We did it ourselves at Affirmative Risk Management when we were the third party administrator for
mhm.
some syndicates in London. And you might be getting to what some of the penalties are. But I do want to mention real quick because you mentioned if there are other issues that you can end up on Medicare. But usually, when we think of Medicare, we think of elderly, like 65 and over, and Medicaid for impoverished or people. And
People who don't have private insurance.
yes, but I want to point out that there can be 3-year-olds who are on Medicare. So it's not just for the elderly.
Right.
So I had many an attorney when I was working claims go, my client is 17 years old, and I'm like, yeah, I know, but they can be on Medicare for various reasons. I'm gonna need the big five.
That's why you need to report every claim to CMS.
Yes. Every single claim. And do you know why? I figured, Bill, you're going to tell why. Otherwise, I want to tell why.
Tell why.
Oh, okay. Because it is $1,000 a day fine for
Yep.
every day that you do not report that person. So, and that could put any kind of insurance company out of business if you think
Yeah.
about it. I
It's a
mean,
bad day.
yeah, it is kind of like a no crap kind of deal. And again, many plaintiff attorney would be like, yeah, yeah, don't worry about it. We will pay Medicare or Medicaid or whatever. And I'm like, fine. I want you to sign me over an indemnity agreement saying that you're going to pay this $1,000 a day fine until, and I mean, it doesn't like, oops, we just figured it out. No, no, no. It's like from when it starts to when it finally gets over. And you know how fast the government moves. Glaciers move faster. I think the ice age like ended before Congress will like pass a bill or something.
Right.
I mean,
Right.
so this is something you need to do early. Like
Yeah.
get those people at least started through the CMS system and find
At,
out,
at least before you try and settle it.
yes, yes,
Because you really can't have, and that's one of my biggest gripes about that whole
mm,
CMS system is that
mm,
when you're working with a person on Medicare
hmm
who's not represented by an attorney,
hmm
and I try and explain to them that we really can't talk about settlement until we have the information from CMS,
it
they're
sounds
like,
shady.
yeah, they don't want to hear it, they don't believe it,
Uh,
they just want their bills paid.
Because let's just go over this real quick and then we can probably move on to reviewing medical records or liens or valuations and negotiations and stuff like that because this is all very much part of it because it is so backwards. So when a person who is on Medicare has finished treatment and you've already gone to CMS and Medicare says yes they're receiving or Medicare or they have Medicare at the end, when they finish treating, you send another letter back to Medicare saying, okay, tell me how much treatment they got for these particular like ICD-10 codes or CPT codes or whatever for that particular injury for this particular accident. Medicare will come back and say, this is the tentative amount. And you're like, great, that's not what I need to settle the claim. This is the tentative amount. I need the final amount. So you're like, okay, great. What's the final amount? And they want you to go back to the claimant and go, this is the tentative amount. So this is the tentative settlement amount that I'm going to do, but I have to wait until CMS or the Center of Medical, whatever it is, tells me what the final amount is. So you push back again, and then Medicare will come back and say, yep, that's the final amount. And then you're
Mhm.
like, great, I'm going to pay them. We're going to settle. But I mean, you see, there's like three steps, and it sounds super shady. Super shady.
It's tough for them to get their brain around.
Yes.
A
It's tough
lot of
for me
times
to,
you just when you say, well, Medicare has a claim to anything they've paid before we pay you. Sometimes you hear them go, oh,
yeah.
so they kind of get it because they've been exposed to
Mhm. We
the
used we used to, and then we'll move on, I swear. We used to have a letter that explained everything that
mhm,
we would give our claimants, along with literally a flow chart.
mhm,
Because the letter is long because it's the government, and
yeah.
sometimes I need pictures because I've got a short attention span.
Yeah.
So anyway, that's another thing to think about. I don't know if you are listening and you're with, I don't know, Allstate or State Farm or whatever, you don't have one. That's okay. You can't send it. But if you're a smaller company like Bill, maybe you do. There you go.
And Medicaid is
Hmm.
different. Well, here in New York, it could be different in other states. I don't know. I know Pennsylvania's like this, but you go to the county. You go to
Oh,
there's an office in each county that will handle the Medicaid for that person.
let's also talk about liens. Massachusetts has a lien, and I think it's Pennsylvania too, where you have to call them and find out if there is any past due child support
Oh, yeah, I've
or
seen. So
taxes.
that's interesting.
Yeah. And I I remember this one case. God, I think the guy got like $1.50 left because he had not paid child support. I mean, it's bad. We're laughing, but we're also that poor child.
Right.
Do your duty. Anyway, this is not the point of the podcast. Point of the podcast is to educate you. So as an adjuster, you got to find out all of these little bitty things that we have to know about. So,
Yeah.
how does valuation and negotiation go, Bill?
So once you figure out what this claim and the injury is worth, and there's we've talked to folks who take the position that carriers should be making the offer up front. Most of my carriers don't do that. It's different, wherever you go. People's opinion about that can vary. I've never seen a study as to whether one way or the other yields better results. One way or the other, a conversation has to be had about how much it's going to take to get a release signed.
Hmm.
And
How do they do it if they don't make an offer first? Like, because,
ask for a demand, ask for what it'll take to settle the claim.
oh, okay, 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 okay.
Explain special damages, explain
Mm,
general
I
damages,
see.
and just say, okay, what are you looking for to settle this?
Okay,
The
okay.
carrier has agreed to, XYZ.
I,
Somebody's got to make the first move, whether it's the
yeah,
carrier,
yeah, yeah.
it's I've done it both ways, still do it both ways. It
Mm,
depends on the authority that, we work at the behest of
mhm.
insurance carriers who give us
Right,
authority.
right.
So we'll
I,
go off of their kind of direction.
yeah, I've done that both ways as well. It's usually the attorneys who will make, a demand first, like by
If there's an
sending you a
attorney,
demand package or whatever.
yeah, if there's an attorney involved, most often we expect them to send a
Yeah.
demand package.
But
Uh,
for an unrepresented claimant, I always made, you know, the first move.
mhm.
I always called them and explained, okay, so, this is what I'm seeing, yeah, blah, blah, blah. We'll probably get into that, so I'll let you talk more about that.
Well, the approach where you make the offer first, especially like if you have an attorney and you
Mm,
see the case, you got all the medical records, you got your head around liability. And by the way, when it comes to liability, you don't necessarily determine liability and then get records.
right.
A lot of times you can't really figure liability out until you get the records. Like, was there a toxicology report? Was this person, under the influence? So there's anyway, that order can be
Yes.
moved around. But the point is that when you button all that stuff up, if you approach the attorney and say, "Look, we see this as X amount of dollars," the theory is that by doing that, you're grounding the attorney and
Mm,
letting them know, this is not a claim up here. It's
yes.
not a claim down here. We think it's right about here. And that, in some theories, will prevent the attorney from saying, well, I want your policy limits, when it's not a policy limits case. So whether that work, like nine
Yeah.
times out of 10, when you do that, they're gonna double or triple that for their demand anyway. And
Right.
they're gonna say, I don't care what you think. This is what we think it's worth.
Sure. Yeah, and
And the conversation nets out that you're really just kind of finding common ground as best you can. And when you
right.
can't, then it goes to suit. And then they do this in a, settlement conference
Right.
later.
I do want to point out, though, something that I don't think a lot of adjusters are familiar with, and at least not anymore. I don't think they're being taught this, so to speak, quote unquote, taught, is that we have to let our insureds know what the offers and the demands are. And FYI, I just want to do a little definition thing. The insurance company makes the offer, and the plaintiff, meaning the claimant, makes a demand. So just these are the two words that we're using. And what you should do as an adjuster is send out a letter to the insured saying, Dear Mr. Insured, I am making an offer of $1,000 to settle. And then the next time that it comes back, dear Mr. Insured, the plaintiff has demanded $15 billion, and I've made an offer of $1,500. Please let me know if you receive lawsuit paperwork because failure to do so or failure to answer in a timely manner could, jeopardize coverage, yada, 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 yada.
Yeah, I know in some states that there's an obligation to provide a copy of the demand letter to a policyholder, and I
Hmm.
don't think that's the case in every state. I
No,
don't
I
believe
actually
that's the
have
case in New York here.
I actually have
Um,
not heard that, but I do know in Texas, and some of the more, I guess, plaintiff-oriented states, they do have that, and you might as well just do it. Keep your insured appraised because I've seen too many lawsuits that come down that says this could have been settled within policy limits. It wasn't, so I'm suing for bad faith, and then I get involved.
right.
You know,
Right. I think that if you are dealing with a claim that could potentially approach policy limits, then you definitely need to notify the
hmm
insured of what's going on.
hmm
And we call it an excess letter, that there's a
Yes,
potential for an excess claim
there
and
you
that they
go.
need to notify, maybe talk to their own attorney about that.
And
So,
you had mentioned if we're just like at loggerheads with either the claimant or their attorney, it could go to litigation, or if, we're just running out of time, right? And we get up to the statute of limitations or whatever, so they have to file suit. You call the insured, by the way, and say, hey, you might be receiving a lawsuit. You need to let me know immediately
mhm.
because if we don't answer on time, there could be a coverage issue, right? And then of course you write that down and you document that in your notes. So, real quick, what are the steps in litigation?
In litigation,
Yeah.
they first file a summons and complaint. and then they serve that upon the insured with a process server. And then once the insured is served, they should be letting their insurance company know right away. That insurance company will assign a defense attorney
Hmm.
who will then file an answer. And and then it's just a bunch of motion practice where one side demands basically evidence or discovery from the other side. And they go back and forth sometimes for years doing that. Depositions will be taken.
Yeah.
And then in
Sometimes you go
most
through
cases,
mediation,
yeah, in most cases, the judge will call for a settlement conference where I'll get
exactly.
everybody in a room and he'll say, look, can you guys work this out so we don't have
Right.
to go to trial?
Yeah.
If they can't reach an agreement for whatever reason and there's issues of fact, then what'll happen is there'll be a what's called a note of issue filed, and that basically sets forth the date that the trial process will start.
Hmm.
They'll go through voir dire and select a jury,
Hmm.
and then there's a trial. And then that trial could be bifurcated into liability or damages. Not always, and I'm not real familiar with that process because by the time it gets there, we're investigating first notice losses,
Yeah. Yeah.
doing other stuff. So, but that's the eventuality of it. And then once a settlement is reached, then the plaintiff has to file a stipulation of discontinuance, and that closes down the litigation piece of it.
Right.
And once the release is signed, then it's kind of an agreement that the claim is extinguished from now until the end of the world.
Exactly. Yeah. And even if we don't go to litigation, we still want to get that full and final release. And I do want to point out that it is always a good idea to find out if the claimant is married and get a husband-wife release because the spouse could have a claim loss of consortium, not just about sex, guys. It's
Mhm.
not just about sex. It's about household loss of household services like cleaning or mowing the lawn or gardening or picking up the kids or ironing or, whatever. So make sure that we get that release of all claims. If they are children, they usually have to have an ad litem, which does mean that we go to a court real quick because the court has to make sure that we are protecting the children. And they have a statute for what, 2 years after their 18th birthday or whatever the statute date is, like
Yeah,
2 years, 1 year, 3 years, whatever, after their 18th birthday.
yeah, yeah. So that's
Yeah.
the anatomy of a slip and fall claim.
Wow. This is I mean it's in depth, and it's hard and
And the
so
funny thing is, any one component of what we talked about today, we could do a whole episode on.
oh, absolutely. Absolutely, absolutely. But you know what we're going to do in 2 weeks, since we're
What's
still
that?
going to be talking about the winter wonderlands, is navigating auto liability
Yes.
and ice and snow.
The
So,
funny thing is, a lot of the structural part of a claim from start to finish on a slip and fall case is going to apply to just about any liability claim.
yes.
Um, the difference is going to be the components of the investigation, how you're determining fault,
Mhm.
um, lots of other things. So
Yes.
medical bills with no fault.
Oh, you know, it's just so much fun.
Yeah.
I gotta say, not a big fan. I mean, I get the point of something like Michigan or something like that where they have the no fault things, but I get confused over the threshold, damage thresholds, monetary thresholds, verbal thresholds, whatever. But hey, you know what? We don't have to talk about that now because we're
No.
finished. We will see you in 2 weeks, I guess.
Yes, ma'am.
Thank you. See you
Bye-bye.
later. Bye.
Thanks for joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.auten.claims. And for anyone interested in working as an independent liability adjuster, go to the Contact Us tab to join our roster.
In the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.